Welcome everyone. My name is Jeana Singleton. I'm an attorney here at Brennan, Manna & Diamond. I practice specifically in the healthcare space. I'm super excited today. We have a panel from Flannery Georgalis, which is probably, in my opinion, one of the best white-collar defense firms around, particularly in the healthcare space. So I think that you'll really enjoy hearing some of the war stories and getting some real-life examples about how you take fraud and abuse compliance and how it can go wrong, but how we can also learn from other people's misery, I guess, and prevent some pretty significant consequences for your practices. So I appreciate you all being here. Let me get my slides up here. I just have a few introductory slides, and then I'm going to turn it over to the crew over at Flannery Georgalis and allow them to do what they do best. So just a minute. All right, so you should see my slides. Just a quick overview of the current environment. So healthcare, it's one of the most regulated industries in the US. The legal action comes from the US Department of Justice, and it's the largest portion of the GDP. In fact, I read a study at one point that said that healthcare is the #1 regulated industry in our country. Nuclear energy is #2. So it's actually harder to deal with healthcare than it is nuclear issues at times. Congress has increased their funding for enforcement over time, and government investigations are occurring on an ongoing basis. There have been new investigation units that have been created throughout the years. There's a duty to self-report, which came into being after the Affordable Care Act, and then there are increased penalties that we're seeing also. The enforcement actions kind of focuses on 3 different areas. There could be specific types of behavior. So maybe it is a specific deal between a hospital and physician, or maybe there's a patient assistance program. It could be a specific industry, meaning, or I guess a sub-portion of the healthcare industry. It could be home health, laboratory, PBMs. Those are hot areas. There are other areas. Pharmacy is another big one. And then the third bucket is that in addition to the federal issues, you also have state-specific issues that come up with healthcare fraud and abuse also. So you always have to keep in mind that you've got your federal laws, which will govern what you're allowed to do in the healthcare space, but you'll also have state laws, and they're very different between the states. So something that might be okay in Florida is definitely not okay somewhere else, or vice versa. So as a quick refresher, everyone loves to come to me and say, I have this great business idea. And I said, great, let's hear it. And then inevitably it's, well, we can't do it quite that way. And they're like, why? It makes business sense. And I say, well, it makes business sense, but this is healthcare and we have special rules. So just because something makes sense from a business perspective does not mean that it's going to be compliant from a healthcare perspective. So there are marketing practices, investments, and contracts, which are everyday practice in other industries that may not work in healthcare. But as I've told our audiences before, our job is to keep you out of trouble, but it's also to tell you how to do things compliantly. So usually if the answer is, well, you can't do it that way, usually there's something else that you can do that is compliant. So we try to focus on that end and the prevention, right? From the regulatory scheme perspective, there are 3 federal healthcare laws. Actually, there's 4. There's one that's not on here. The Anti-kickback Statute, the Stark Law, the False Claims Act, and then there's a 4th one called EKRA, which is actually becoming a pretty hot button issue these days. The Anti-kickback Statute is very simple. You can't give or receive anything of value in exchange for referrals to a that can be reimbursed by a federal healthcare program. The Stark Law says that if you are a physician specifically, or an immediate family member of the physician, that you cannot refer to yourself for government referrals for any designated health service, which is a very specific definition under federal law as to what qualifies as a designated health service. But that is a very, I guess it's more limited in scope than the Anti-kickback Statute. It's still a hot button issue though. And then the False Claims Act, which says that you can't lie on your billing, I guess is the easiest way to put it, right? You have to be honest and accurate in the way that you bill. If you violate the anti-kickback statute, it's automatically a False Claims Act violation. So those work together. And then the fourth one, which I forgot on my bullet points here, is EKRA, the Eliminating Kickbacks and Recovery Act, which is a fairly new law. I think it came out in 2018. And what that is that EKRA is kind of a narrower version of the anti-kickback statute. The original intent was that they were trying to prevent kickbacks in the addiction recovery and treatment space. However, clinical laboratory, in a very broad sense, got put into the law at very last minute. So even if labs are doing things beyond addiction labs or toxicology labs, they are still subject to EKRA. Now, for all of these, there are certain exceptions. Well, False Claims Act, that doesn't have exceptions, but there are safe harbors and exceptions for anti-kickback statute, the Stark Law, and EKRA. And if you can meet those exceptions, they can help you on the compliance end, but you need to be very careful because there are potential monetary penalties as well as criminal penalties, which I think our team from Flannery today will be able to share with you what happens when things go awry. At the state level, a lot of states have self-referral prohibitions, their own version of an anti-kickback statute, which may apply to commercial, may not. Insurance may apply to Bureau of Workers' Compensation or Medicaid. So you really have to know what's specific to your state. And then fee splitting prohibitions are in some states also. There is a duty to refund overpayments when it's appropriate. The Affordable Care Act came up with this requirement saying that you have to actually proactively disclose and return any overpayments that result from a mistake or erroneous claim. The final issue came out in 2016, so at this point we've got a nice amount of track record as far as how to go about doing refunds of overpayments and the self-disclosure. There is time to do an investigation, so you need to make sure that you really parse through all the claims and make sure whatever you're overpaying, whatever the overpayment is like properly identified, and then follow the process to get through. But the key takeaways are that the refund over the self-disclosure and overpayment refund rules apply to Medicare Parts A and B. There's a separate rule for Parts C and D. There's a 6-year look-back period, so you can go back pretty far looking at these overpayments. Once the overpayment is identified, you've got 60 days to refund it. And the question is always, well, what does it mean to identify the overpayment? It means that you have time to investigate and make sure you know clearly what is going on and identify all of the claims. Generally, you get 6 months to investigate or do due diligence as if an issue is raised. So according to CMS and their fact sheets, the most common types of fraud include billing for services not rendered, billing for non-covered services as if it was covered, misrepresenting dates of service, locations of service, who provided it. On the provider side, I'll tell you, we get a lot of questions about incident to billing and whether it's appropriate to bill under someone else's number. Those rules are very, very specific. And I think sometimes our providers are still caught off guard with how difficult it really is to bill incident to appropriately. And we also get a lot of questions about, well, what if I have a new provider starting? Can I just bill them under someone else until I get them credentialed? And the answer is no, that doesn't work. You can only bill someone under their own number, or if you can meet the incident to billing rules, then you can bill that way too. But you just can't bill under somebody else's number until you get a new provider set up. Waiving of deductibles and co-payments is an ongoing issue. That's also a state level issue. So there are state laws that say you cannot waive patient responsibilities as well. Incorrect reporting, unbundling of services, overutilization of services. This is a really big topic in the enforcement world, particularly with lab and other ancillaries. Of course, the corruption such as kickbacks and bribes, and then false or unnecessary issuance of prescription drugs. So that's kind of an overview of the hot topics that are out there for CMS.
Jeana, were those, I'm curious, on that slide, were those in any way ranked by something that you pulled, or are they not in any particular order?
No, so that CMS published a fact sheet, and that is just their list.
Okay.
Yep, I'd be curious to hear you guys' take though on what you think the biggest issues are.
Yeah, I think you'll get a sense of that as we kind of go along. It's funny because I think that's the right list in terms of probably frequency, but if you adjust the list for dollars of resolutions, it probably looks differently. So
that's kind of what prompted my question. Yeah.
Yeah, and I think what's interesting too is these are pretty high dollar areas that you guys are dealing with. Usually, when an enforcement action happens, it's not over a $10 copay. It's over something much, much bigger. And then just to wrap it up here, just a quick reminder that there are ways to prevent compliance issues and fraud and abuse. The number one thing you can do is have what we call a living, breathing compliance plan. And I say that because it is all too easy to say, well, I have a compliance plan. We implemented it 10 years ago and it sits in this binder on the shelf somewhere, or it's located somewhere on the server, but nobody knows where it's at. A truly living and breathing compliance plan means that the policies are updated regularly, that you come back, you educate your team on them on a regular basis, that there are compliance audits and spot checking happening on some sort of scheduled basis, so that there is this track record of making sure that you can show that your organization takes compliance seriously and that you intend to comply with the law. And I think that we'll probably hear from our team over at Flannery Georgalis in just a little bit about how measures such as having a compliance plan and actively implementing it can really help you out on the defense side when you're arguing about things such as intent to comply. And maybe, I guess my hope is on our side that having an active compliance plan will mean that you won't need someone like Flannery Georgalis someday. But I'm glad they're there for people who do need them. Make sure you always engage legal counsel that really specializes in healthcare to review business structures prior to actually jumping into them. It's a lot easier to fix something before it happens. Self-disclose and repay when appropriate. As I said before, self-disclosure is a requirement if there is an overpayment that occurs. So you want to make sure that you know how to do that or work closely with your legal counsel on those processes. Don't be afraid to ask questions regarding compliance. It's that whole idea of an ounce of prevention is well worth it in the end. And of course, in your organization, you want to encourage a culture of compliance. This idea of we don't ever want anyone to feel like they will be penalized if they come forward with a compliance question. We want them to feel welcome to raise issues. They want our team to feel like they are active participants in this compliance plan, and we want to foster this culture that, hey, we want to do the right thing that's legally compliant and just the right thing for our patients too. So with that, I am going to pass it over to our friends here at Flannery Georgalis. I'm really excited to hear what you guys have to say.
Thanks so much, Jeana. I think, Paul, did you want to lead us off before we kind of get into the meat of the slides here, or?
Sorry about that. By way of quick introductions, my name is Paul Flannery. I'm one of the founding members and a partner here at Flannery Georgalis, and Colin Callahan is here with us today, and also our partner Justin Withrow as well. Justin primarily is with us in the Cleveland office where I am. Colin heads up our Pittsburgh office. Colin, like myself, is a former federal prosecutor. Colin was in the United States Attorney's Office in the Western District of PA in Pittsburgh for almost a decade. His experience is very unique. We draw on it regularly here in that Colin began his time in the United States Attorney's Office as a civil enforcement litigator, predominantly in what we call the ACE units, the affirmative civil enforcement units for the government. So he spent a ton of his time really reviewing, assessing, analyzing, and making ultimately intervention decisions on behalf of the government in complex False Claims Act matters, largely in the healthcare space. And about halfway into his career as a federal prosecutor, he flipped over to the criminal side, where the office drew on that experience a lot, and Colin was doing largely complex healthcare fraud investigations and prosecutions during that time. Myself, I'm also a former federal prosecutor. I was here in the Cleveland office, the United States Attorney's Office. My partner and I both were in the major fraud and public corruption unit during our time there. We did a lot of healthcare work here in the Cleveland office as well, investigating and prosecuting complex healthcare fraud matters. Justin and I actually met, one of the highest compliments. We were in the opposite side of cases from one another from time to time. He is a defense attorney, me as a prosecutor. I was always exceptionally impressed with him and his preparation and how well he advocated and handled matters on behalf of his clients and some of the amazing results that he was able to obtain for them. So when my partner and I left the U.S. Attorney's Office to form Flannery Georgalis, he was high on our list to recruit to come work with us, and he's been amazing and brings a ton of experience not only in the healthcare space as well, but it also in particular, Justin has developed a rather niche practice in the area of representing dental providers as well and dental practice groups in a wide variety of enforcement and sensitive matters. So he's got a volume of information expertise in that regard. But we're delighted to speak here today. Jeana, thank you again for inviting us to talk. We always enjoy teaming up with the folks at BMD doing these types of presentations, and we love working with your firm. And before I turn it over to Colin and Justin to get us rolling here, I want to reiterate a couple of things that Jeana said is that we've been able, and I know Jeana has as well, and the folks at BMD get a lot of amazing results and do a lot of amazing work for their clients. If there's one factor that I think is the single greatest factor in terms that can be the determination of success in these types of matters, particularly when we're talking either serious civil enforcement or criminal, it's involving counsel early. And the earlier that folks, let's say on the compliance and the advice and consultation side are in terms of setting up operations or setting up business practices and things of that sort, and that living, breathing compliance plan, that's great. And then to the extent that there does become some sort of inquiry from regulators, whether it is civil or criminal, the quicker that you get experienced counsel involved to do that, there's a direct relation to, I think, the types of successful results that we're able to obtain. Okay. So with that, Colin, I'll turn it over to you and Justin to get us rolling here.
Great. That's fantastic. And in sort of the vein of a bunch of trial lawyers, some of what we're going to talk about will be generally useful information, and some of it will be still useful information, but also war stories, because that's what we sometimes do. But I think even those war stories will have some direct application for everybody here. So I'm going to go ahead and pull up these slides and I'll share them with the group. I think I should be able to do that. Bear with me 1 second. All right. Okay. So obviously we're talking here about healthcare fraud, abuse trends, and how to stay compliant. You know, that's the general approach here. And here's some nice pictures of what we all looked like when we were a little bit younger.
Oh, Colin, I don't think your slides are showing up.
Is that right? Okay.
Yeah, I think you're sharing the other screen.
Yeah, go to share screen and then.
Okay. Bear with me, guys. Okay. See it. They're showing up as stop screen for me. Okay. Let me try it again.
There you go.
Okay, wonderful. All right. So they moving for everybody now as well? Okay. So the specific subtopics that we wanted to get into today that are delineated here are just a couple of the hot topics that I think are out there from an enforcement perspective right now. You know, most of them relate directly to some of the issues that Jeana had already talked about a little bit here. And they really do run the gamut from, you know, issues that are more about particular kinds of relationships. And that's the sort of reason that whether it's DOJ or Medicare or Medicaid, CMS from a regulator's perspective are focused on them. And some of them, you know, focus a little bit more on either the nature of the manner in which services are provided or frankly, the individuals that are involved, right? And the first particular category that we want to talk about in that regard is the latter. And this is really private equity enforcement. And from my vantage point, this is a field that and an area that is going to be really gigantically important over the coming years here, and we're already seeing quite a bit of it. As I suspect most of the folks on this webinar today are aware, we have seen just an enormous explosion in private equity money being invested into the healthcare space over the last decade, half decade in particular. Some of that is a function of having prolonged low interest rate environments, where investors have understandably been looking for new and more lucrative places to sort of realize returns on their investments. And overall, I happen to be a big believer that that's going to be a fantastic thing for the healthcare system. But anytime you have large expansions in money, anytime you are dealing with that kind of volume and change in a heavily regulated industry like healthcare, you're going to see both political and enforcement efforts increase rapidly at the same time. And that's certainly what we're seeing here. A couple of examples on the political end are listed here. Going back to last year, you've got the House Ways and Means Committee holding pointed hearings on private equity's expanded role in the system. Earlier this year, you had President Biden in a State of the Union address making express references to what he characterized as Wall Street firms taking over nursing homes in particular, and then connecting in the course of the speech there, purported failures in the quality of those homes, staffing levels, etc., to the influence of that private equity type money going into that particular sphere. And mostly to this point, from a False Claims Act perspective, but this is easily transferable as well, onto the criminal side of things. DOJ's position increasingly is that they are absolutely interested in looking at private equity firms as potential defendants in these types of civil enforcement or criminal actions. And some of the bolded language that you can see here, it has traditionally been the thing that these cases have turned on, where a private equity firm is potentially in the crosshairs of the government. And that's really whether or not they had sort of a quote, active role in whatever the underlying scheme, or alleged scheme might be. And where DOJ makes a determination that that is sufficient, then we increasingly are seeing private equity firms not just being, targets of potential investigations, whether the investigation involved kickback allegations or services not rendered or false billing, really can be anything under the False Claims Act, and then again on the criminal side as well. And a couple of examples here that we pull up, I could talk about this for half an hour. I'm not going to. Nobody needs to get nervous. But there's lots more that we could sort of deal with here. This is a Southern District of Florida case in particular, and it really kind of serves to underscore DOJ's position and focus on what the role of the private equity firm was in a particular case, and that controlling whether or not they actually move forward with potential here civil claims against them. This particular case, which was against RLH, amongst others, that was the private equity firm that was involved here. In many ways, a pretty common pharmacy AKS fact pattern, except the allegations here weren't made just against the pharmacy, but instead included a variety of AKS-oriented allegations against RLH itself. And there were a couple different permutations here. There was an alleged AKS scheme that related directly to marketing compensation paid to marketers by the underlying pharmacy. Then there were also copay waiver sort of alleged schemes and certain telemedicine schemes that were alleged as well in the relator's complaint, which was ultimately adopted by the government in this kind of setting. This is a notable case because it got to a motion for dismiss opinion. So RLH was challenging essentially whether or not their connection from a False Claims Act perspective was sufficient, whether they did have a sufficiently active role in their underlying investment in this company to hold them responsible. And kind of following that active involvement type language that we saw earlier, here the court ultimately found that the AKS violations that related to the compensation being paid to marketers could move forward, and therefore the AKS case could steamroll forward. Then granted the motion to dismiss, though, in contrast, and found as sort of a factual allegation standpoint, there was not enough of a connection between the private equity firm on the copay waivers and the telemedicine schemes, and that was sort of the resolution. And as is so often the case in significant False Claims Act cases, once you take your swing and you don't get a complete dismissal of the action, here RLH went ahead and settled the case to the tune of $21 million. All right. And, in recent years, this has been a fairly, standard way of thinking about where the dividing lines might exist for private equity. I should also note, these were issues that essentially started and continued after RLH was involved in the venture as well, which I think for the court was a relevant consideration. Was not, for example, a situation where the private equity firm had perhaps bought problems they didn't know about, right? Second case, though, in this area is a little bit different. Fact pattern here, you had a chain of behavioral health care centers, this is up in Massachusetts, that were alleged to have been using unlicensed and unsupervised staff to provide mental health services to Medicaid beneficiaries. This one actually gets to the summary judgment stage. So you've got pretty extensive litigation in this case with very good, sophisticated defense counsel on board in this one. HIG is actually the private equity firm involved here, and it gets to a summary judgment decision before ultimately settling for $19.5 million. And the facts here the posture here was a little bit different as well in some interesting ways that I think, tell us some important things about how this is going to work going forward. In this particular circumstance, the core behavior about these unlicensed and unsupervised staff actions was actually something that largely happens and goes into place after, or rather, it was already in place and then was essentially ratified after HIG had made their investment. So this actually was a circumstance where, from a defense perspective, traditionally you might have argued, this is us buying problems we didn't know about. This isn't something that you can directly connect from a governmental perspective to, private equity innovations or new policies that private equity is sort of imposing on an entity. Still didn't matter here, though, because as the court evaluated the summary judgment record and ultimately determined that the case could move forward and denied the defendant's motion for summary judgment, they were actually dueling motions for summary judgment in this particular circumstance. The court made, two really key findings in reaching that determination. From a knowledge perspective, the court here determined that there was enough evidence in the record that HIG, the private equity firm, either knew or should have known, because that's the relevant standard for civil enforcement standards here, that this particular supervision issue would have a regulatory impact. And that was sufficient for False Claims Act purposes to essentially get over the scienter hurdle. And then from a causation perspective, the court also got into the fact that there was a sufficient ties here between, the board and HIG, which, had the power through that board representation to have potentially fixed these regulatory violations, that it was sufficient to move forward from a False Claims Act perspective. And so, in this case as well, you ultimately reach, a settlement of approximately $20 million. But this one sets off more alarm bells, I think, in the defense bar, because it's a bit of an expansion of what we had traditionally seen as sufficient facts to allege private equity liability directly. And it raises a host of sort of, kind of issues that anybody that is on either side of a private equity deal really needs to be sort of thinking about in today's sort of healthcare enforcement environment. One of those issues is, really taking the due diligence process seriously, where potential investments are in the offing. If you're a purchaser, you need to know what you're buying. If you're, contemplating a merger, you need to understand what you're merging into. And, that due diligence can't just be the same type of due diligence it might have been 10 years ago, where sure, you're thinking about, compliance issues from a CLIA perspective, or do people have the right licenses? All of that stuff's important, right? But you also need to have folks that understand compliance, evaluating what kind of compliance program is on the books, what kind of representations are being made. From a private equity perspective, if you're going to have a relationship, what level of day-to-day business operations and control are going to exist? What kind of communications are going to be created as part of that relationship? Is part of the attraction of the investment management type services that, the PE firm feels like that it can provide, that perhaps come with reporting obligations or new metrics and the like that are going to flow back and forth, all of which in, a certain kind of case, the government can look at as signs of private equity firms trying to influence the underlying portfolio company in a way that, from a certain jaundiced view, is designed to increase profits while potentially sacrificing patient care. Now, I don't actually think that's, generally speaking, what people are trying to do when these things happen, but you have to have an awareness of how those day-to-day operations are going to run and how they can look later on as well. Jeana's already talked about this, and this is true in private equity, but it's true everywhere. Early and ongoing investments in compliance are always going to be key. And then when in doubt, seek advice of sophisticated counsel. We see enormous deals getting done all the time. We see enormous investments being made in expansions of healthcare capacity. And, all too often, unfortunately, the least amount of focus is being paid on the need to scale up compliance programs and compliance capacity as you were sort of scaling up the rest of your venture or growing through a merger or through an investment. And there's just far too much evidence out there of what the cost of that can be on these enforcement actions and other regulatory issues. And so the answer really is, get with a BMD, talk to a Jeana Singleton on the front end, make appropriate, investments in your compliance program, figure out, as Jeana put it before, the right way to get where you want to get, because you can still generally do that and don't create problems for yourself later. By the same token, if you get a call, you realize you have a problem belatedly, get counsel involved earlier on that end of things as well. So that's a quick overview on sort of the private equity.
Something else, Colin, we've seen too is challenges in the insurance space for coverage in some of these types of situations where there are claims being made, but they're arising out of conduct, and there's questions as to whether or not that's covered, given that it was pre-existing conduct and things like that, and you have new owners at times coming in, private equity. But that's an area too that's extremely complex, has a lot of pitfalls to it, and we've certainly been involved in cases where folks have been on the unfortunate end of claim denial or coverage denial in some of these types of situations.
That's a great point. Yeah, I mean, it's very complicated generally, and it's just not the kind of thing that you want to try and navigate without appropriate counsel and assistance.
I have a quick question for you, Colin. So I think it's fascinating that the private equity firms are at risk themselves also, because I mean, private equity is a hot place to be right now in healthcare, and it has been for a while.
Yep.
And I know the cases you talked about, there were some pretty substantial fines that were ultimately paid. What about on the criminal side? Are they going after private equity firms for criminal activity?
They are, and it's a still growing area, is what I would say. We have, I think some of that's the function of, during COVID, we saw even a larger doubling down on the private equity sort of investment side of things, I think. And although it had been growing obviously for 10, 15 years already. And so the other thing COVID did, though, from an enforcement perspective on the criminal side, it created a few high salient sort of issues, with the nursing home context being probably the most obvious example, where you now have sort of political actors that have some investment in trying to find folks to blame for problems. And so, I've got a couple of open matters right now, just at a high level, that involve, private equity controlled or partially controlled nursing homes, where those investigations clearly are trying to develop, or in a couple of instances have already developed, what the government thinks is potential criminal liability as to the private equity firms themselves. And, that's not going to be where that stops. But we see criminal cases being developed against corporate entities, which of course in this sector can essentially mean the death penalty, for the entity itself, enormous corporate fines. And, what I expect to see is, continue rooting around to charge, executives or individuals at private equity firms potentially with criminal charges as well.
And you can see that private equity expansion, beyond the nursing home space as well. It's very prevalent in the dental arena. Dental support organizations, DSOs, as they're commonly referred to, are really one of the hot issues in dentistry. And there have been a variety of investigations by state and federal regulators and looking into what's called the corporate practice of dentistry. So as private equity has come in and purchased a large number of dental practices and put them under one umbrella entity, they come in and they try to, systemize processes and, maximize, dollars for the business when they have a patient in the operating chair. And so from the regulator's perspective, they scrutinize whether the services that have been rendered to a patient are what was medically necessary, or if designed to perform work that wasn't necessary, but more so designed to increase the profits of the practice.
Yeah, that's a great point. That's a great point. All right, I'm going to move us on to the next topic, just because I want to keep us, kind of on time here, which would be telemedicine enforcement. Obviously, a growing area, and we'll let Paul or Justin talk a little bit about this one.
Sure. So as we all have probably experienced in our personal lives, telemedicine has become a prevalent part of everyday life during the pandemic. Regulators, HHS, Congress, even, and CMS have, provided numerous flexibilities aimed at expanding access to telemedicine services during the pandemic. Some of those flexibilities and loosening of restrictions are temporary, and some of those are likely to be made permanent, such as allowing Medicare patients to receive at-home audio-only services for certain mental and behavioral health care. But with the increased flexibilities surrounding access and reimbursement for telemedicine services, it's also led to a proliferation of civil and criminal investigations of a variety of fraudulent schemes involving not only medical providers, but the telemedicine companies themselves. And from the government's perspective, really the exploitation of an acceptance of the use of telehealth. And while the schemes vary, charged defendants can include, as I indicated, the providers themselves, telemedicine company executives, laboratories, marketing companies, durable medical equipment companies. A common element generally exists in all, and that's the payment of kickbacks or bribes in exchange for referrals by medical professionals working in conjunction with these telemedicine companies. Importantly, many of the ordering providers, and what you can see generally consistently throughout these schemes, is that oftentimes the providers never interacted with the patients, or alternatively only had very brief interactions with the patient. In fact, just the other day, there was an Aurora, Ohio-based physician that pleaded guilty to criminal charges, actually in a district court in St. Louis, Missouri, where she was authorizing orders for certain pain creams, certain durable medical equipment, when this particular provider had no interaction with the patients, and in some instances, the patient didn't even have a request for, the care that she was rendering and the orders that she was prescribing. So in response to the increase of telemedicine, the Office of Inspector General for Health and Human Services has recently issued a special fraud alert. Now, these are extraordinarily rare. In fact, this is only the 5th special fraud alert that OIG has issued since the late 80s. And OIG typically issues a special fraud alert to address specific trends in healthcare fraud and certain industry-wide practices. And because of the pandemic, telemedicine certainly falls into that bucket. So the alert that OIG issued cautions healthcare providers and entities from characteristics, and in fact, suspect characteristics of telemedicine arrangements. And so, Colin, if you can go to the next slide, please. There's 7. So the first being patient recruitment. So the patients for whom the healthcare provider orders or prescribes items or services, if they're identified or recruited by a telemedicine company using a telemarketing company, call center, a health fair, through the internet, OIG has indicated that is a suspect way of recruiting patients. In the example that I just provided previously, where there's insufficient patient information. So a provider is provided with patient information, but it's minimal. It may only be demographic information. It doesn't allow the provider to adequately assess, the needs of a particular patient. As always is going to be a focus of any telemedicine relationship is compensation. And where compensation is based on referrals and the telemedicine company compensating the provider based upon the volume of items or services that they order, that is certainly a suspect characteristic that is going to draw scrutiny from regulators. Now, that's not to say that any one of these 7 characteristics in and of itself would result in a telemedicine relationship to be improper or illegal, but you can rest assured that where there are one or more of these characteristics in a relationship, you are certainly under heightened scrutiny from regulators. The nice thing about this special fraud alert from OIG, it allows providers in this space to evaluate if they are in these types of telemedicine relationships, evaluate those relationships to ensure that their conduct doesn't fall within one, or worst case scenario, all of these characteristics, because this provides those entities and those providers essentially a roadmap as to how OIG and other regulators are going to evaluate whether their relationship is improper and potentially illegal. So as opposed to talking about all 7, I think some of them are pretty self-explanatory. We can go ahead and move on to the next slide. So in conjunction with OIG's issuance of the special fraud alert, there was a significant telemedicine takedown orchestrated by the Department of Justice. As the slide indicates, it was on the same day that OIG released their special fraud alert, and it was a coordinated effort. And so the Department of Justice and other government agencies on a nationwide basis charged 36 defendants with more than $1.2 billion in fraudulent healthcare schemes involving telemedicine services. Similarly, at the same time, CMS commenced administrative actions against an additional 52 providers who were alleged to have participated in similar schemes. Some of the defendants charged were allegedly controlled a telemarketing network both domestically and overseas. And the unfortunate part about this is, the elderly and other disabled patients, who really benefit from the telemedicine services that they have access to, they were victimized in these schemes, and they were identified as easy targets to utilize to access their information and then ultimately bill for services that were either unnecessary or for orders that were never actually rendered. This recent takedown was just one in a continuing series of DOJ takedowns in the past few years. In 2019, there was Operation Brace Yourself, which had a strong component of telemedicine and durable medical equipment. Operation Double Helix, and several others, where DOJ will continue to prioritize telemedicine relationships and the enforcement of relationships that are improper. There was one particular case,
and talking about the elderly folks, and between elder fraud and I know it's not necessarily an instance of elder fraud, but elder fraud and abuse and COVID-19 are probably, from an FBI threat band perspective, like slightly below national security right now in terms of what they're looking at.
That's a great point, Paul. And I think you did a lot of that work when you were in the office. I was the elder fraud coordinator as well as the healthcare fraud coordinator for a while in the office out here. And I think the current administration has elevated those roles even more. I was liaising with the government fairly recently on behalf of a victim in a case, and initially a friend at the FBI said, I just don't know if that's enough money. And then I clarified that it was for somebody that qualified, as elder status essentially, and I got a much different reception, and they were interested in the case. So it's a great point.
Fraud and elder abuse or fraud, they really don't have the same types of thresholds they do for more traditional fraud, even healthcare related matters. Yeah.
And Justin, Paul, I'm going to jump us ahead real quick here, if that's okay. I think from a slide perspective, this is a great example of an enormous sort of dollar value case, as well in the telemedicine space. But just to make sure that we kind of get through the range of topics here, I'm going to jump to the EKRA enforcement side of things. Jeana,
if you don't mind, can I just say one more thing? And so,
sure.
My comments were primarily focused on there is criminal exposure, but in April of this year, DOJ actually settled the first False Claims Act. So moving into the civil side of enforcement on these telemedicine relationships too. So there's a civil component and a criminal component as well. Sorry.
No, that's a great point. Sorry about that. Yeah, you're absolutely right. It's going to continue to be huge. From an EKRA perspective, Jeana already talked about this, that EKRA was originally, designed as sort of an AKS tag-along that was going to focus predominantly on what were perceived as fraudulent or problematic practices in the sober home and toxicology lab space. The challenge, which some of the folks on this webinar may have sort of realized at this point, is that the actual language of EKRA ended up being broadened late in the legislative process, and DOJ has interpreted it to broadly apply to all clinical laboratories, for example. And that's created sort of a growing series of problems and challenges on the enforcement end since the law became effective in October of 2018. And in particular here, what's sort of interesting and timely is that we've got kind of dueling opinions that have come out over the last year or so that take very different sort of legal reads on exactly what EKRA does and doesn't apply to. And it's hugely important because although there are safe harbors or exceptions that can apply to STARP or AKS or the like, EKRA is much narrower in terms of the exceptions that it creates as a statutory matter. And, many of us got excited when we saw a District of Hawaii opinion come out in October of 2021, where the exact scope of EKRA came into play here, where the court held that an percentage-based compensation in a laboratory recruiter's contract did not violate, according to the district court here, EKRA, because the court interpreted EKRA as not applying to a recruiter who was only marketing to doctors rather than referring individual patients directly. And it was essentially a statutory language interpretation there, such that in the District of Hawaii, at least at the moment, the prevailing authority continues to be that EKRA only prohibits things like percentage-based compensation payments to marketers based on direct patient referrals, which in many ways would take us back to sort of the state of play that many people thought was occurring pre-EKRA, where if you brought somebody on board, from a W-2 perspective or the like, and you wanted to pay percentage-based compensation, that was permissible if you dotted your I's, you crossed your T's. Unfortunately, even right from the moment that decision came out, most of us were skeptical that this was going to become the prevailing view. It's certainly contrary to the view that the government has staked out. In fact, just a few months ago, they recently, issued another indictment in a criminal case under EKRA, where they continue to take an expansive reading of it. And this Northern District of California case, it's a 2021 indicted case. But it's one where the defendant was just actually convicted at trial earlier this month, about 2 weeks ago, I should say, reaches a very different result. And I think this more encapsulates what the government's view is, and therefore what we should all sort of be thinking about from an EKRA scope perspective. Here, the government alleged that the defendant, who was the president of a healthcare company, had paid kickbacks in violation of EKRA to marketers and physicians to induce ordering of sort of bundled services. The defendant tried to dismiss the indictment in this particular case, in part by arguing that EKRA didn't apply, similar argument to in Hawaii, because marketers didn't work with patients directly. Again, it was going through physicians and physician relationships. That motion was dismissed. Essentially, the government's perspective was endorsed, and the court held that an inducement to refer an individual can violate EKRA, even where the marketers are paid on a per specimen, per person, or percentage of reimbursement bases, even if there is no direct relationship between the marketer and the patient themselves. And so we don't yet have Court of Appeals opinions on these issues. There may be, additional cases yet to come that could clarify things. But from a compliance perspective, as folks are thinking through how to structure compensation arrangements so that they are EKRA compliant, more important than ever to get somebody like Jeana, somebody like BMD involved, make sure that your compensation plans are really being vetted appropriately and are keeping up with the current state of the law. And by the same token, if, as all too often happens, you have enforcement efforts, subpoenas, CIDs, other requests for records coming in, even from an audit perspective, you should be thinking about and retaining experienced counsel to help respond to those information requests as well, to make sure that you're sort of triaging any situations that may arise under EKRA. Anything else, Justin or Paul, that you guys wanted to add on the EKRA front?
But one thing that I think is important, I know we have a lot of attorneys, and particularly those with healthcare experience here and folks in the healthcare industry here today. It may not necessarily be common knowledge, though, that we talked here today about criminal and civil enforcement, and Jeana even asked, okay, we understand you talked a lot about the types of civil enforcement there, but what about criminal on this? Healthcare, and there are other areas of enforcement that are similar to this, but this sort of parallel ability to have parallel proceedings going on between civil and criminal, that does not occur in all forms of criminal enforcement in the federal code. So for instance, like a public corruption bribery scheme, if someone is under investigation for that, the bad news, so to speak, is among a lot of things, is that there is no way to convince prosecutors to, hey, why don't you handle this as a civil bribery matter, and I'll pay money or I'll pay fines, but I'm not going to have my liberty at risk. Or in a traditional wire fraud or bank fraud, those types of matters, there's not always like a neat sort of well-established parallel proceeding that through which that you can convince the government that it should toggle between one or the other. healthcare is unique, to a degree unique in that regard, and it's important to keep that in mind because it reinforces the need for counsel to be involved early and reinforces the value in extraordinarily proactive and organized responses to the government to try to either keep things in the civil arena or drag things back from where they might be in the criminal arena back into the civil arena. And that requires a level of experience and knowledge of how to navigate that system to do it, but it's important to keep in mind.
Those are great points. All right, in this next topic area is one that, in talking with Jeana, I think we both thought was really kind of timely, and it's not really, it's a different fact paradigm that raises a lot of the same analysis that some of the other things we've already talked about do, and it's really, what are the AKS implications where, somebody wants to serve in a role as, a door opener looking for a finder's fee, basically where the pitch is, I can make you an introduction, I can get you access to people in my network, and I'd like to be compensated for that. Is that acceptable in a way, that doesn't raise compliance concerns? And, can that be viewed in a similar vein to some of the marketing relationships that often will, result in significant AKS scrutiny from a criminal or civil or both perspective? And, I don't know that we need to spend a ton of time analytically talking about this, other than I think it's important for everybody to be aware of this fact pattern, because I think it's transferable, across sort of the healthcare business perspective. And oftentimes, the most important thing isn't going to be, is this kind of a relationship potentially acceptable? I think clearly the answer is yes, but it is, how do you structure and paper this in a way that you can feel completely secure that the way that this is being executed on the ground and the actual benefits that are being paid for don't create AKS problems. And, that level of detail and execution is really the kind of thing that, in my view, can only be done through counsel. If you're trying to, this is an example where you're talking about $1 million finder's fee example, for example, where the value of the doors that are being opened may be $10+ billion worth of, business or referrals. DOJ comes across that kind of a pattern, they're going to be very skeptical that where you got to that compensation level isn't varying based on the value or volume of, a business that's looking to be acquired. And they're going to be very skeptical that this isn't really camouflaging what would otherwise be a potentially problematic marketing relationship. So, we don't have to spend a ton of time on it, but it's something that I think we're seeing more and more come up in the healthcare space. And it's definitely something that we all want to be aware of as being potentially problematic if not executed appropriately with counsel. The last area that we were going to hit here, COVID-related enforcement issues. Some of these, really are related to what we've already talked about, but the COVID-related environment has drawn a lot of that stuff back to the surface. So Paul or Justin, I don't know if you want to give a quick overview of some of these.
We have a minute or two left. We've talked about a lot of this. I think that there's two things that I would say on COVID-related enforcement. First of all, it's extraordinarily serious to the government. It is at a level that is unprecedented, at least that I have seen in my career. The level of task force that have been set up, the level that the DOJ has gone to every single United States Attorney's office in the country and essentially said, give us your 1 or 2 smartest, most aggressive federal prosecutors, because they're going onto a task force with some of the smartest, best agents we have in the area to do nothing but hunt down COVID-related fraud. And the fact that they have almost no thresholds whatsoever on what they will take and what they will prosecute, it has really been mind-blowing in that regard in terms of what we've been seeing. The other area the other point that I know has been very, very significant, and it's gaining traction, and it's particularly gaining traction in the plaintiff and the whistleblower bar, is that for every PPP loan that was applied for, there is a certification that had to be made that the applicant was not engaged in any type of illegal activity under federal, state, or local law. And so now when folks come to Flannery Georgalis from time to time because they have problems in the criminal space. And it could be completely unrelated to some of the things we're talking about here. But if they obtained a PPP loan, and some businesses obtained 5, 10, 15, $25 million loans, those are being looked at now as being false certifications then that were made to the government, making that a false claim, making that now subject to treble or potential double damages for that. And these can become what was a manageable problem, let's say, even albeit criminal, but a manageable issue, whether it was in the tax space or in the regulatory space, now became an absolutely existential threat to the business because of that perspective. And that has been something that's been a real game changer that we've seen now, and we've seen a lot of motivation on the in the whistleblower area on that particular angle as well.
So I think we're probably at an hour, but if anybody wanted to stick around and had any questions, I know that I'm certainly happy to stick around a bit, but we also don't have to. So.
Well, thank you, Colin and Paul and Justin. We really appreciate your time today. And thank you to everyone who is attending. If are there any questions before we wrap up? No? Okay, great. Well, don't hesitate to reach out if you have any questions. This webinar was recorded for future reference as well. But thank you so much for your time, and I hope you all have a great weekend.
Take care, everybody.
Bye-bye.
Thanks, everyone.